So good afternoon, everyone, and thank you. We're going to turn off the slide here. Good afternoon, and thank you for joining our session. This is the latest program in a series of programs called Civil Disagreements, which is a series of debates and discussions on contentious legal issues that are sponsored by the American Bar Association, Reform for Illinois, local Chicago chapters of the American Constitution Society, and the Federalist Society. So my name is Tiffany Middleton, and I manage programs like this one for the American Bar Association's Division for Public Education. The mission of the division is to educate the public about law and legal issues. We want to send thank yous to the Chicago chapters of the American Constitution Society and the Federalist Society, as well as Reform for Illinois. And then also a special shout out to Rick Hassan for his help with, he's the nationally recognized election law expert, for his help in assembling this panel on what proved to be some short notice. Today, we are honored to have a very distinguished panel to discuss the issue of whether the disqualification clause of the 14th Amendment bars Donald Trump from serving as president again or running for president again as a result of his involvement in the events on January 6th, 2021. I think that everyone can understand what events those are, the official counting of the electoral votes from the 2020 presidential election in Washington, D.C. Our panelists include Mark Grady, a Regents professor at the University of Maryland, a noted legal historian on the 14th Amendment, and his most recent book is called Punish Treason, Reward Loyalty, The Forgotten Goals of Constitutional Reform After the Civil War, and it is from this year. We also have David Frum, the esteemed political commentator, author, and senior editor and contributor to The Atlantic magazine. Allen Sumrall, a rising postdoc at the University of California, Irvine. And then we welcome our moderator, Carolyn Shapiro, who's the Associate Dean for Academic Administration and Strategic Initiatives, co-director of the Institute on the Supreme Court of the United States, and professor of law at Chicago-Kent Law School, as well as a frequent media commentator on significant media issues. A few housekeeping things. All of our panelists have either written or spoken publicly on this issue over the past several months. Needless to say, we're honored and delighted that they're all here with us, and that they will participate in the discussion today. Put all of your questions in the Q&A feature at the bottom of your screen if we're all familiar with Zoom by now, and we will try to get to those during the last part of the program. So without further ado, we turn this over to Carolyn.
Thank you, Tiffany. And would you mind putting up the slide that you have of the text of Section 3 of the 14th Amendment so we can just all know what we're talking about to start with? Thank you. Thanks to the ABA, thanks to all of the sponsoring organizations, and thanks to the panelists for being here. I'm really honored to be moderating this event. But I did think it was useful to start with this text because the text says a lot of things, but it leaves a lot of questions unanswered when it comes to whether or not Donald Trump is potentially disqualified from being or running for president. Some of those questions are just about the text. For example, what does insurrection mean? What does it mean to engage in insurrection? And we will discuss those questions and more. And then there are practical questions that the text does not directly address, such as who decides, when and how, whether somebody has been disqualified under this provision of the Constitution. So I think we can take down the slide, at least for the moment, and maybe we may decide to put it back up later. But for the moment, the way we're going to start is that our panelists are each going to speak for about 3 minutes or so to give some opening remarks. Professor Graber is going to go first, followed by Allen Sumrall and David Frum. And they will focus to different degrees on different aspects of the questions that I've already flagged. So, Professor Graber.
Thank you very much, Professor Shapiro, Ms. Middleton, and the conference organizers. The topic for our discussion today is whether a person is constitutionally qualified to be the Chief Executive Law Enforcement Officer of the United States, who, when that person was the Chief Law Enforcement Officer of the United States, knowing that protesters had come to Washington, D.C. to violently disrupt the transition of presidential power, incited those protesters to engage in that violence and refrain from exercising his official powers to stop that violence. Section 3 of the 14th Amendment provides a framework for answering that question. Donald Trump is a past officer of the United States who took an oath to support the Constitution and is seeking again to become an officer under the United States. The persons who drafted Section 3 over and over again referred to the president as an officer of the United States, the presidency as an officer under an office under the United States, and the presidential oath as an oath to support the Constitution. No reason exists for a different interpretation today. The persons who framed Section 3 believed an insurrection involved 2 or more people who resisted federal law by force for a public purpose. The events of January 6, 2021 involved 2 or more persons resisting federal law by force to prevent the transition of presidential power. The persons who framed Section 3 believe that anyone who incited an insurrection was a participant in that insurrection. The evidence indicates that Donald Trump incited an insurrection. There is no reason, I would argue, to think that the framers were wrong when claiming that no government official who incites violence against government officials implementing the law is fit to be a government official in a constitutional democracy. Now, today we're going to discuss and probably disagree on the best procedures for disqualifying such a person, but there is one procedure I'd like to put in everyone's mind we can all agree on. Imagine at the end of today or at some other point, you are convinced that Donald Trump incited an insurrection against the United States. I would argue you have a constitutional obligation as a citizen to campaign against Trump and to use your vote to disqualify him from ever again being President of the United States. Thank you.
Thank you very much. And Mr. Sumrall.
Yeah. Thank you to the organizers for having me. This is, I think, personally kind of exciting for me to be on a panel with these other people. So thank you for having me. I hope I can add something. My views on Section 3 are, I think, pretty similar to Professor Graber's. I don't want to duplicate anything that he said, but I think I sort of understand it as analogous to impeachment a little bit. Because it's a mechanism that was put in place to disqualify people from holding federal office if they've shown by their actions that they are disloyal to the preservation of the constitutional order. It is, I understand it, in effect, to be sort of a mechanism of constitutional self-preservation, and it's designed sort of to help constitutional democracy perpetuate itself. And for those reasons, it does, I think, pose a real problem for Donald Trump. I think the crux of the disqualification question, at least the legal one, is going to hinge on how we define insurrection or rebellion and sort of the minutiae of the evidence about Trump's role in January 6th. But I think my 2 points that might diverge a little bit from the others are, 1, the kind of who decides question, and then 2, about the wisdom of applying Section 3. So first, I'm not convinced that this should be a question for judges and for the US Supreme Court. I understand that there have been lawsuits filed in numerous states, Colorado, my home state of New Mexico. I think there's an original action pending in the Supreme Court in Minnesota. And it very well may end up in front of the US Supreme Court. But I think Section 3, by its terms, leaves room for other constitutional actors like state secretaries of state who have equal obligations to obey and uphold the United States Constitution to do their constitutional duty and apply Section 3. We live in an increasingly jurisdicratic regime where courts dominate much of the political process. Courts increasingly decide questions that might otherwise be left to more democratically accountable officials. And I think that there's at least a strong argument that it's important to let state and local officials do their duty and actually do politics rather than taking this process off the table and giving it to the courts. And then my second point, which I'm still working through and I don't have strong feelings about yet, but I do share the concern that I think a lot of people do about the wisdom of disqualifying Trump from holding office, because if that happens, then surely his supporters will be very displeased. There's a very real threat of violence. And I think that's a concern we ought to take extraordinarily seriously. At the same time, though, I'm not convinced that the alternative is better, because defeating Trump at the ballot box might result in violence, just like it did in 2021. Or the consequences of Trump holding another term as president may be severe in ways we cannot yet foresee. Moreover, and finally, I think the threat of violence should not dictate our constitutional decision-making. If it does, I fear we've lost control of our constitutional democracy. And that threat evidences a separate but very real problem about the fragility of our constitutional democracy that very well might actually be remedied by applying Section 3.
Thank you. And Mr. Frum.
When Section 3 was drafted in 1866, the drafters had a very specific problem on their hands. President Andrew Johnson was building a political organization for himself by distributing very large numbers of pardons to previous rebels, in the hope that the well-founded hope that they would support him for re-election to the presidency in 1868 to give him the term that he had not been elected to. He succeeded after the assassination of President Lincoln. Congress and President Johnson's other opponents in the states met this challenge by writing a very specific and narrowly tailored remedy. They removed the power to restore political rights from the president to the Congress. And they said, from now on, the president loses this power, Congress has it by 2/3 vote. Now that was an unwieldy mechanism, and it was only there to meet an immediate contingency. As soon as President Johnson left town and President Grant was in his place, Congress dispensed the pardons. In 1872, they gave wholesale pardons to almost everybody who'd been involved in the Southern cause in the Civil War, and made Section 3 moot for a very, very long time. At the time that Section 3 was written, there was very little question, very little difficulty about how it was going to be enforced. If you were a local rebel and you got yourself on a ballot, the local commander of the occupying Union Army would strike your name. And if you didn't like it, you were welcome to make the burning of Atlanta best 2 out of 3. The whole rights revolution, the whole due process revolution, that was 100 years in the future. Nobody imagined such a thing. This was a temporary wartime measure. This was a post-war measure enforced by wartime power. No appeal, no rights, only the army. Now, that was 150 years ago, and Congress, as I said, made it all moot in 1872. Suppose we try to take this mummy out of the tomb and reanimate it and bring it back to life. What would that look like? We go into the election of 2024, and 1 or 2 or more state secretaries try to say in more or less swing states that in that state, Donald Trump's name can't appear on the ballot. At which point the whole thing goes to the Supreme Court, which may take jurisdiction or may punt it as a political matter. And we are left then with a true chaos. Suppose this plan worked in the technical sense. Suppose it was true that by taking Donald Trump's name off the ballot in 1 or more swing states, that Joe Biden were reelected with a plurality of the vote. Does that stick? What happens? One of the big problems we have as we contemplate the very serious threat of a second Trump presidency, and I take it very seriously, is a belief among a lot of Americans that there is some Harry Potter cheat code that can get us out of this dilemma. On the Trump side, they believe that the president can say, I pardon myself, and his problems are over, as if the rest of America then says, oh, well, you said the cheat code, we lose. And on the anti-Trump side, there's this idea that somehow by getting the Secretary of State of Colorado or some other state to disqualify Trump and let President Biden win with Trump's votes not counting or Trump's votes not taken, that they can make Trump go away in a way that the country will accept. None of that is feasible. Now, I attended law school. I'm not a lawyer by training, and I certainly don't sit on the law faculty. But I really do want to appeal to people here not to think like lawyers for once, even in this legal education context. Think like historians and think like people who are responsible citizens dealing with a threat to democracy that cannot be wished away.
So thank you all for those opening remarks. There's so much to talk about. I think I do though want to start with a question for you, Mr. Frum, based on what you just said. A lot of what you said is obviously about the prudence of trying to keep Trump off the ballot. But I'm curious, based on the historical analysis that you bring, whether you think that the framers of the 14th Amendment intended for Section 3 to have a lifespan beyond the immediate time period that it was written. And some people have argued it really only applies to the Civil War and the Confederate veterans.
Yeah, I don't know the answer to that. But what I do know is I think a lot of it, we can clarify a lot if we look not at the rule they laid down, but at the remedy they offered. The remedy tells us a lot about what they had in mind. And the remedy was to transfer power from the president to Congress, from Johnson to the radical Republicans. And that tells us something about how eternal they thought this problem was going to be, because this is a very clumsy, if there were ever another insurrection, this would be a very clumsy way to decide when do people get their political rights back, when are they punished? Because what it does is it separates the criminal and the political consequences for disloyalty to the United States. Note one other thing about this that makes me really worry about this as a piece of drafting. In the 1787 Constitution, you can be punished for treason only by confession in open court or by the testimony of two witnesses to an overt act. Section 3 gives a much more broad definition of treason for political purposes. Treason that it looks like Congress alone, without the protections in the 1787 Constitution, can make you a traitor for the purpose of your political rights, not for the purpose of hanging you, but for the purpose of political rights. I'm not sure if you thought really clearly about this as a solution for the ages, that you would have mismatched the treason penalties in the way that this does between the 1866 rules for treason and the 1787 rules for treason.
Professor Graber, you look like you want to jump in.
Yes,
but
this is my normal look, though.
But maybe you could give your take on whether or not this was intended by the framers to extend into the future, or whether it really was designed for just for the moment.
There's a difference between saying the priority was for the moment. They were after a particular problem. I would describe the problem a little bit differently than Mr. Frum, but they were after a general problem. They did not want former Confederates to rule the former Confederate states and Congress. On the other hand, the original drafts said people who participated in the late rebellion. They changed that. They changed that because people said, no, we want it to be any rebellion. And that's what they said on the floor of Congress. They were quite clear that someone who takes an oath to support the Constitution and then engages in an insurrection isn't qualified. They didn't think the problem would be nearly as severe as it was in 1866, but they would tell you if in the year 3791, an officer takes the oath and then is engaged in an insurrection, that person should never again be an officer.
Maybe we could turn for a minute to the question of who decides, because I think that's, at least in my mind, one of the hardest puzzles here. That even if you conclude that, in fact, Donald Trump engaged in insurrection, the mechanisms, as both Mr. Frum and Mr. Sumrall have pointed out, are problematic just as a practical matter. So, Mr. Sumrall, to bring you into the conversation, could you talk a little bit about how you think it would play out if, in fact, local officials, local election officials, state level election officials refuse to put Donald Trump on the ballot for this reason? You think, one question I have is it actually possible to keep that out of the courts? And another question I have is, what is your response to David Frum's point about the negative consequences that would flow from that?
I mean, I think to be sure, I share a lot of Mr. Frum's concerns about the consequences. I don't disagree in any sense that it would be chaos, I think. But I do want to at least emphasize. So I think before I jump into sort of the meat of the question, I think several secretaries of state have at least expressed public hesitation about answering the questions themselves, and that because they have said with variations of, we have to wait for the courts to decide this question, basically choosing forbearance and hoping that the courts will answer the question, which is a classic strategy that politicians have done, not just in the United States, but across the world, in handing questions to the courts to effectively save face to their constituents, because they don't want to make the hard choice, which is, I think, rational from their perspective, because they want to continue to hold office. But I also think there's a strong argument that is them abdicating some of their own constitutional responsibility to enforce Section 3. So I think a lot of this hinges on what people have been saying is whether Section 3 is self-executing or not. And I think, as surely other people understand, that term, I think, is a bit of a misnomer, because it's not as if the Section 3 exists in the ether and is going to do something itself. It does require some constitutional actor to do something. And I realized that because of just how kind of court-centric and judicialized so much of our politics has become, that's why the courts likely will get involved and already have been involved. Like I mentioned, I'm aware of a handful of state and federal cases that are asking state and federal judges to, in effect, order state secretaries of state to remove him from the ballot, which helps the state secretaries save face and say, well, the judge made me do it, or I can't do it because the judge wouldn't let me. And I think while that might remove some of the very real concerns about them losing their office, or perhaps the chaos that would result from certain states doing certain things, I also feel like that's the nature of how the amendment works, and that's also a nature of federalism and a nature of democracy, is that elected officials have to make hard choices, and if people don't like their choices, they can remove them from office. And I think, as Mr. Frum has emphasized, in the background of all of this discussion is that authoritarian tendency among an increasingly large part of the American electorate that is going to react in ways that we don't like. And I think, and I don't have the answer to that part, but I do want to emphasize that I think ideally this process would be left not necessarily without courts entirely, but I think state and local officials would also do their part in making some of these hard choices, and not just saving face and letting the courts do it, because I don't think having courts decide these key questions about who our elected officials are is a healthy thing for American constitutional democracy either.
Great, thank you. We were hoping that Judge Michael McConnell would also be joining us, and of course he's not with us, unfortunately. But I did want to raise an argument that he's made somewhat tentatively in some things that he's written. He's suggested that one of the problems with relying on Section 3 in this instance is that it could lead to the sort of tit for tat, a situation where it becomes a very partisan back and forth, and that any time, for example, a politician supports or speaks in support of the objectives of a political riot, that's a quote, we might see folks on the other side calling for that person's disqualification from any office, because obviously Section 3 doesn't apply only to presidency, assuming there's a little debate about its application there, but it applies to all kinds of offices. So I'm curious, I'd like to know what all of you collectively think about that argument in favor of, as he puts it, the narrowest plausible reading of the term insurrection for purposes of Section 3.
Shall I start?
Yeah, please.
Well, first, the problem of enforcement to the authors of the amendment was not a problem at all. As I said, the enforcement would be done by the local Union Army commander, and he would have guns. And if you didn't like it, he'd won the last round of fighting, and you were invited to try another at your peril. So they didn't think about that, and they didn't imagine a world in which all kinds of executive decisions could be litigated in the courts. That world only exists because of the 14th Amendment and because of interpretations of the 14th Amendment that wouldn't exist for 80 or 100 years after the 14th Amendment itself was ratified. So you have to pull the future into the past to allow them even to contemplate this. I think Judge McConnell's absolutely right. I mean, there was an incident in Tennessee where 3 members of the legislature behaved in a way that was unquestionably disruptive to the proceedings. They were told by the chair of the Tennessee legislature not to do it. They staged a symbolic defiance of the orders of the chair, and they were then had their seats removed from them, and new elections were forced. If you know Tennessee politics, it's not at all improbable that the Secretary of State of the same party that removed those people would then say, you know what, they were insurrectionists. They can't ever stand for office again unless 2/3 of Congress, of the federal Congress, both houses of federal Congress pardons them. That could absolutely happen. Again, I think it's just a lot of this is about how you see the world. When I'm asked about the problem of can the president pardon himself for federal crimes? The answer I give, one way to think about this is to look at the text and structure of the Constitution, and that's, I think, a way that is very natural for lawyers to think. The way I think is, if the president can pardon himself for federal crimes, that means the president can murder the first lady in the White House and maybe be impeached and removed, but never stand trial for murder. It means that the vice president of the United States can murder the president, instantly write himself a pardon, and then be president. And again, maybe Congress could impeach and remove him, but he would at least be immune from punishment for his crime. And those results seem so obviously crazy that the theory can't be true. And what I invite people to consider is, when you think that the result of how detrimental and how counterproductive the results of trying to deal with the Trump problem in this way are, it warns you that the theory is defective. Because if I know this again, that there's a kind of there's a kind of intellectual integrity in the law, that the very fact that the result is perverse proves the power of your legal analysis in getting to the perverse result. Because
not always like that.
But any ordinary person could get to a non-perverse result, but it takes a specialist to get to a perverse one. But in this case, I think the result that my view would be, if the results are perverse, then the route to the results is probably mistaken.
Look, let me just ask a follow-up, though, which is, and then I'm not trying to keep the rest of you out of the conversation, but you indicated in your opening remarks that you take the dangers of a Trump presidency, a second Trump presidency, very seriously. And obviously, I've read many of your writings about this. Is that a perverse result as well? That a person who tried to overturn an election to keep himself in power could then become president again?
No, because if this remedy would work, then we wouldn't have the problem in the first place, would we?
Well, I guess I'm not following that.
If it were true that a law officer of a state or states could say, Donald Trump committed an insurrection, he can't be on the ballot here in Colorado or Minnesota or wherever it is, and if the country were to say, oh, absolutely, okay, the Secretary of State of Colorado has spoken, so it has been spoken, so let it be done, we all stand down and we give up on Donald Trump. If that worked, then we wouldn't have the problem. The reason we have a problem is because you have very large numbers of citizens who don't see the matter that way. And invoking the Harry Potter cheat code won't change things. All it will do is make sure that I hope, I believe probable, and I hope more than probable reelection of President Biden, all it will do is make sure the guarantee that that next presidency will be completely illegitimate in the eyes of very large numbers of people.
Professor Graber, do you want to respond either to my
Okay,
question
the
or
first
anything?
thing, I agree with one point, and that is disqualifying Donald Trump is not the solution to serious problems that ail the United States. That lots of things aren't going to go away. There is a great threat to our democracy. It extends beyond Donald Trump. But having said that, well, I guess we should not elect a Democrat, because we know when we elect a Democrat in a close election, that causes violence. We should not prosecute Donald Trump for any crime, because that is likely to cause violence. I mean, Donald Trump and too many people of his supporters are like the kid who cried, cheater, 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 anytime the kid lost. What you gradually learned was you could not accommodate that kid. You hope to convince lots of kids around that maybe that kid was a little crazy, but all you could do was do what you felt was fair, because the kid was going to cry cheater whether the kid lost fairly or unfairly. So the question really is this fair? And here I'll add, I half agree again with Mr. Frum. I think the Republicans, it wasn't simply a general, that one of the goals of the 14th Amendment was that the Republican Party would determine how things operated, because then parties were the primary vehicle of constitutional meaning, not courts or legislatures. We now have a different theory. The result is, as Mr. Sumrall has correctly said, the framers don't help us at all on the best procedure for disqualifying Donald Trump. All we can ask ourselves, is this a fair, good procedure? And I'm a legal historian, and what I would say about that has no more expertise than anyone listening to this.
Mr. Sumrall.
Yeah, I also want to respond to something Mr. Frum said earlier about sort of if one rogue Secretary of State were to disqualify somebody and everybody were okay with that, then we might not have the problem in the first place. And I think I agree with the sort of assumptions and the thrust of that, but also the 14th Amendment creates a mechanism for if there is a rogue Secretary of State who makes a bad decision. Everybody else says, no, we think Donald Trump should be on the ballot. And there's one rogue Secretary of State who says, I want to disqualify him from California or something that would remove a lot of electoral votes. Then Congress could purportedly, by 2/3 vote, remove that, like in effect, overturn the Secretary of State's decision and remove the disability, I think is the phrase, and leave the person on the ballot. Which I think is also a sort of a healthy democratic mechanism, because then that requires the Secretary of State to have taken a stand on the evidence and say, look, if this is what my constituents want, then this is what I'm going to do. And if everybody sort of collectively in Congress at the national level, if there's a national outcry to that, then perhaps that person should lose their job, and Congress can take a stand on the evidence and say, no, we think this person should be on the ballot. So I think in effect, it might require Congress to step up and take these questions seriously, which of course there is a very real pending threat of sort of malignant partisanship that exists in Congress. But I think ideally people would take those questions seriously.
Are there other mechanisms besides what we've talked about so far? Is the possibility of individual officials keeping Trump's name off the ballot, and the possibility of the courts deciding whether or not his name can appear on the ballot or he can serve as president? Are there other mechanisms for enforcement, assuming we think that the terms of Section 3 apply to prevent him from being president?
I think on a probabilistic measure, if I were to say what would the courts do, the likeliest outcome is they just bow out. And the federal courts especially, and say this is a political matter. And you know, our analysis, this actually, the text suggests strongly that it's Congress that makes these decisions. So it would be Kevin McCarthy and Chuck Schumer who get to decide whether Trump is on the ballot, not us. Leave us out of this. The second most likely outcome is they would rule for Trump. The least likely outcome is that they would rule, in my opinion, is that they would rule for the Secretary of State who tried such a thing. I am not here deterred by the threat of violence if laws are enforced. I have been a big advocate of enforcing the laws because we have a long and well-established tradition of applying the law to serving presidents. That's why President Nixon needed a pardon from President Ford, because if he had left office without the pardon, he would have been vulnerable. Everyone agreed he would have been vulnerable to prosecution for things he did as president. President Clinton was disbarred he settled out of court, but he faced legal consequences for the things that he had done as president. We have just seen the son of a president be indicted for things that the son has done. So we have a broad, well-accepted tradition. And by the way, and President Trump's manifold prosecutions are going forward without disruption. And in general, I think that these threats of violence against well-established, it's not the threat of violence. That's not what I'm worried about. The state is more than competent to deal with violence, as we saw on January 6th. I mean, that the Capitol Hill police were caught by surprise, but by the time the National Guard showed up, and the capacity of the state to deal with violence is clear. The threat is that the winner in such an election will be, after such a novel proceeding that has no standards to it, and that will probably occur with the courts saying, leave us out of it, let the secretaries of state, and if the secretary of state in a state can get away with it in that state, then we have nothing to say. If that's the way it happens, you have a massive legitimacy problem. And the country already faces such problems. This only makes it worse in a way that I don't think accomplishes anything. As I say, if this were the remedy, then we wouldn't have the problem.
Well, think of a procedure in a different way. And that is, whether it works or not, may not be the most relevant thing. What the procedure does is publicly have a hearing where there is evidence about Donald Trump's relationship, his participation in the insurrection, to put in front of the general public. This is a good thing for a democracy, regardless of the result, because in fact, our conversation today is so typical of every conversation I've had on the subject. We take for granted that he's probably disqualified. We fight over some very legitimate questions. What's the proper procedure? I think those are very good, legitimate questions. And while I wind up disagreeing with some people, I think they're reasonable. We fight over what's the pragmatism. Again, I think they're very good questions. What strikes me as interesting in these things is, for the most part, we never fight over the question we were asked to resolve, which is, should Donald Trump be disqualified? And I think we all wind up agreeing, if nothing else, he should be disqualified by the American voter in that procedure.
Oh, so let's turning to the question about whether he is in fact technically disqualified, or maybe technically is the wrong word, but the amendment, the section 3 applies to him. There are people, going back to Judge McConnell's point, who say he didn't engage in insurrection. Engaging in insurrection, maybe he would have if he'd been leading the crowd. Maybe we should read insurrection so narrowly as it really involves taking up arms, literally against the United States military, for example. I'm not necessarily endorsing these views, but I think there are plenty of decent arguments for why we should, in fact, read insurrection very, very narrowly, and that it might not, in fact, disqualify him constitutionally from serving as president.
the whole trend of American law in state, in questions that affect the existence of the state, has been toward more narrow accusations. Alger Hiss tried not for treason, not even for espionage, but for perjury. Other people who are guilty of espionage tried for much more technical violations. I think there is something about this that reflects the nature of the American system. The authors of one thing that is very clear about the 1787 Constitution, the authors are very uncomfortable with treason trials. They make it almost impossible to convict somebody of treason. And they absolutely rule out the way that the Parliament of England usually punish you for treason, which was a trial before Parliament, not in front of a court. They ruled that out. There are no bills of attainder. There are going to be no Earl of Stafford cases. There are going to be none of the treason trials that happened under Charles II and James II. None of that. And so I think there is something actually in the DNA of the United States that says when you deal with a straight state-threatening crime, when you have an Alger Hiss, when you have a Tokyo Rose, when you have the atomic spies, try to catch them on something that is highly legalistic, highly specific, and that is what Donald Trump faces. So he's not being charged for insurrection. He's not being charged for treason. Arising from the insurrection, he's being tried for some very specific, highly provable, highly fact-based crimes in a way that I think accords with something deep in the nature of the United States that was founded by people to whom the Earl of Stafford was a real event. The Algernon Sidney trials of the 40 years later, these were real events, and they did not like them, and they did not want to see them occur.
And that's why they passed Section 3. You've just done a brilliant defense of Section 3 because it's not a criminal punishment. What a great many Republicans said, here's the story. We're not going to hang 400,000 Confederate soldiers. We're not even going to disenfranchise them. We're going to take the leaders of the rebellion who violated their oaths and say only one thing to them: you're out of politics. You can make a living in any other way. You can earn as much money as you want, but we're adding a qualification, not creating a punishment. They're very specific on this. We're adding a qualification to office holding in the United States, and you cannot participate in an insurrection. And to some degree, we allow this because it's not a crime. We have the officer do it. We don't demand the same due process standards. We're putting people away because that's the point. Simply disqualify a person for office and not to treat it as a crime, because otherwise you have a real problem. Namely, if you start to define insurrection solely in terms of the Civil War, you can be a living constitutionalist, I am, but they're also worried about Klan violence, which they call an insurrection. And you wind up saying, by the way, Section 3 does not apply to the Klan because they were not overthrowing the government of the United States.
I think here's where it's helpful to, this is sort of something I said in my introductory remarks, but I think here's where it might be helpful to, at least the way that I think about it, is to analogize Section 3 to something like impeachment. I don't think that impeachment is the worst thing that can happen to somebody in American life. It's not a criminal punishment. Being removed from office is serious, but it's not the same thing as being put in prison. And I think both mechanisms, both Section 3 and impeachment, are designed to be constitutional self-preservation mechanisms, sort of as Professor Graeber was pointing out. The fact that you are removing somebody from political life doesn't mean that they can't participate in American society in any of a number of different ways. Which is why I don't think we necessarily have to be too cautious about reading insurrection or rebellion too narrowly, because these are not criminal penalties. These are not extraordinarily serious things. The possibility of not holding the office of the presidency is not the gravest ill that can happen to somebody. And I think if people get too cavalier with disqualifying people, that is also what the people who drafted Section 3 thought about, which is why they created the fail-safe mechanism that Congress can step in and say, wait a minute, we think this person probably shouldn't be disqualified, and we're going to make sure that they can still continue to participate and seek federal office.
But if the goal here is, as Professor Graber said, to have a bigger national conversation about whether what happened on January 6th was a constitution-threatening event, we had the January 6th Commission. We have prosecutions. We have, in fact, more modern ways of dealing with that conversation, that issue, to start that conversation. And by the way, that conversation is going pretty well, but not great. You're bringing along a majority of the country, but not the consensus of the country. Back of Section 3, and also Section 4, by the way, there are many of the same problems within Section 4. What does it mean that the national debt shall not be questioned? Does that mean no one can give a speech questioning it? That these things invoke the public consensus of the Union loyal states, which, because they have the guns and they have the army, are the only public opinion that really matters. And you have a chastened southern United States that accepts that verdict. I went back when, after the election of 2022, when all of these weirdos began being appointed to congressional committees, I went back and looked at the Congress that was elected in 1874. Of course, Republicans have a disastrous election in 1874, and the Democrats win. And who do the Democrats put in charge of the committees of Congress? The Republicans keep the Senate, but they lose the House. And in 1874, the Democrats make sure that every single committee chair they pick was Union loyal. And not only Union loyal, many of them were Union veterans. They did have former Confederates in the Congress. They just made sure they are not going to be the face of our party. I don't think an ex-Confederate got an important role until the Cleveland administration. And when they had to contest the election of 1880, their best chance before Cleveland of getting back into the presidency, they picked the leader of the Union side at the Battle of Gettysburg. So they were very circumspect, because they understood the people with the guns, the people with the money, the people whose population is growing because of post-Civil War immigration. These are the people who set the national mind. And so they can say things like, don't question our debt, but we question your debt. They can say things like, if you were not Union loyal, you can't be, and you were an officer, you can't be a politician again. We accept that consensus. That's not the country we live in, and that's not the conversation that you're going to produce. So I don't want to make this merely a matter of prudence, because I think there are real things wrong with taking remedies that were designed to meet the problems of one historical era and then repurposing them as if history and time didn't exist. But I also think there is a prudential concern here, which is this is a remedy that's really going to backfire. And I would advise people to consider remedies that will work.
One person has asked in the chat, sort of the flip side of this, which is, if Donald Trump were convicted, would that disqualify him? And would that in any way meet any of your concerns, Mr. Frum, or yours, Mr. Sumrall, in that it would be a court proceeding, but it'd be a very different type of court proceeding than what we've been looking at?
I mean, to be clear, I have concerns about the courts doing certain things in American politics, but this is not me saying the courts shouldn't exist in American politics. Courts do have a very important role to play, namely perhaps in adjudicating criminal liability. So I don't necessarily have a problem, at least on that front, with Trump being prosecuted. And I think if he is convicted of any one of, 94 something different counts he's facing across 4 different indictments, then surely at least he might be disqualified, I think, as a few people have said, in the court of public opinion. But beyond that, I'm not sure exactly how that process would play out.
I think from a strict legal point of view, I think it's clear conviction of even the worst felony would not disqualify Donald Trump from the presidency, not legally. But as a practical matter, its impact is enormous. And not just criminal conviction. A year ago, if I wrote in The Atlantic, Donald Trump is a rapist, I would have to, the Atlantic lawyers would intercede and say, you're exposing us to a libel claim. I can write that today, Donald Trump is a rapist in the Atlantic, and I don't have to worry about a libel claim because he's been adjudicated by a court in New York as a rapist. And when Donald Trump said, well, my sexual assault conviction wasn't quite rape, the court then, and there were then some libel issues that arose again, the court then said, in any ordinary sense of the word, you're a rapist. So I can write that in the Atlantic. And if Donald Trump's Republican opponents weren't such worms, they could say it in their ads. And I have every confidence that his Democratic opponents, who are not worms, will say it in their ads, or they could if they had reason to believe it would be decisive. If he is convicted, we'll be able to say he's a felon. We'll be able to say Donald Trump is running for president, but he cannot vote in his home state of Florida because he has been convicted of a felony, and in Florida, felons can't vote. It will have a lot of political matters. When Benjamin Franklin said famously, "A republic if you can keep it," that one of the things he meant by that was that the task of upholding Republican forms of government inevitably, inescapably devolves on the public mind and the public will, and that's just where we are. And one of the things, and that's both a little scary because there is no one to save you, but it's also kind of inspiring because what it means is how this story ends depends on what we do, not on what some court decides.
Mr. Graber, do you want to respond to that at all?
Well, respond is, first of all, about the last minute, I agree wholeheartedly that in the long run, whether Trump is disqualified or not, it will be the American people reacting to the disqualification or the non-disqualification. I think it's important to have the conversation. More important sometimes to have the conversation than the result. Is this the country we want to be? A country that behaves in these ways. I wind up thinking, with respect to Section 3, most constitutional democracies have some version of Section 3. And turns out the roof neither falls in nor is the democracy saved. So in some ways, for those who think it will save democracy, the experience of other countries says no. For those who think the roof will fall in, the experience of other countries also says no. But I think it's in the Constitution. I think it's a good rule. We ought to see if the rule applies.
Having a conversation is helps us figure that out collectively, I think is what you're saying.
Yeah.
We've gone a little bit over, although we started a little bit late. I do want to give our panelists a chance to say any last words before we sign off.
Yeah, I can jump in real quick. I think sort of wrap up. I agree with both Mr. Frum and Professor Graber that the conversation itself is really important, which is part of what we're doing here. But also that I think plays into my larger point about if the courts answer this type of question, they might take it off the table and prevent parts of these conversations from continuing to happen. Because I think one mechanism of Section 3 is it in a sense sets up a dialogue between local officials, secretaries of state, and Congress and the American people to engage with these sorts of questions and over time work them out. And I think the fear of that process and the expectation that we have to hand it to the courts is also evidence of some of the deeper pathologies that exist in American politics. But then sort of on a different note about the worry about applying an antiquated provision to modern problems, I wonder if Trump is not going to be disqualified under Section 3, I wonder what exactly would he have to do to be disqualified? Just how extreme would his actions have to be? And if they have to be much more extreme, what does that say about the wisdom of the American people or the wisdom of Section 3 and Section 3's drafters, that they created a provision that would not disqualify somebody from doing something that Trump has done? And to the extent that we're worried about applying antiquated constitutional provisions to modern problems, that's the purpose of a constitution, is to create a set of rules that are going to tackle problems into the future. I think that's not necessarily a question of constitutional interpretation, of originalism versus living constitutionalism. It's more a question of what do we think a constitution is, and it's designed to create political mechanisms to solve problems into the future. And I think that that has to be something that we reckon with when we confront this question.
South was not chastened in 1866. If you look at the records of the 39th Congress, the reason why we had the 14th Amendment was precisely because the South was not chastened, and the real belief that unless things change, they would refight the Civil War and re-enslave African Americans. So what happened when Democrats took over, and as Democrats were taking over? The Southern elite, by force and violence, by insurrection, took control back over the Southern states, and we know exactly what happened in the South as a result of that violence. Now, though those who remember history are condemned to repeat it. So who knows what will happen? But the Southern story is a story that says there's another way here. When you tell people that the legal consequences of their insurrection, they will not reap it, that increases perhaps the probability that they will engage again until they're successful.
Mr. Frum, do you want to have any last comments?
Yeah. I agree with the point that the South did not surrender entirely in 1865. But what they did do was this. In 1858, the South, or 1856, and certainly in 1846, the South bid, the White South, bid for power at the center. They of course, they had power at the local level, but they bid for power at the center. The Civil War broke them and said, from now on and for really the next century, you will not have power at the center. You will have power locally. You can run your local affairs the way you wish, however brutally, and you may use violence and brutality to do it, but the center, you are excluded, and you must accept that. And you must show at least some deference to which side was the right side. And the Union has been restored, and that there will never again be an attempt to break the power of the Union. That was a very imperfect victory. That's what we get in this life. I think what I devoutly hope and what I expect is going to happen is Donald Trump is going to be seen off. I think he will be mired in his own legal troubles, and I expect that one or another of them will ultimately send him to prison. But the problem we have with more of our fellow citizens than we ever before imagined being committed to authoritarian ideas, that's not going away. I really fear promises that there is some way forward that is non-political, and there's someone else who will do this job for us, and that person wears robes. Last thought. One of the things that I find an interesting paradox about this whole debate is the people who are most looking to the courts, because ultimately this Section 3 only works if the courts agree. The people who are most looking to the courts to save us from Trump tend to be precisely the people who have the least confidence in the courts, least regard for the present system of not the courts in general, but these courts, and look at these judges most of the time and say, I see a lot of people who are taking free vacations who shouldn't be taking them, but I look to them to save us from Donald Trump. It's precisely, I would beseech everyone to remember how you feel about the courts when you read the papers. And to apply that knowledge to how you feel about the courts when you ask them to save the country from Donald Trump.
I'm sure we could keep talking about this much longer. There are lots of questions in the Q&A that we didn't get to, specifically about the text. But I really want to thank our panelists and our sponsors for this terrific event.
Thank you. Bye-bye, everybody.